one more webinar from Mehta Mehta. So today we have chosen a topic, the future challenges and opportunities under the new labor code. And friends, all of us, we deal with this secretarial audit on a day in, day out as a practicing company secretary or as an employee. And somewhere, we are directly or indirectly connected with compliance of those labor laws. And of course, I think majority of us, we have learned this old labor laws, and definitely we need to upgrade and we need to know about what is the new law. And that's what we have just, we have requested, Mr. Shantanu to touch this important topic on those code. And yeah, and some of our members has also chosen this this labor law as in practice area, and particularly town B or town C categories, where a company secretary is expected to practicing company secretary is expected to handle many things. So this is also a very good opportunity for some of us. And so we have chosen our own member, Mr. Shantanu Pethe. Like he's from Indore and Pune. So half of the time he spends in Indore and half of the time he's in Pune also. So basically he's a science graduate and he's also done his MBA finance and qualified as a company secretary in the year 2004. So almost 2 decades of experience as a company secretary post qualifications. He has almost 70,000 YouTube follower. So nowadays that's also a big credentials because that's what people likes you to listen and all. So great, sir. That's something which is very appreciable. And he's a regular speaker and he likes labor laws, and he probably are out of the passion, and he is also into research, and he is associated with many groups and companies. And he has a touch upon very good topics. Like I was on his YouTube channel where he has touched women at night, migrant workers, power of inspector, if any labor inspector comes to your place. So yeah, those are the very important topic which he has touched upon. So welcome, Mr. Shantanu for this program. And we also have, as usual, Mr. Bala, Professor Bala. Again, more than 4 decades of experience, worked in a multinational company like Foseco India. And he's always our guide and philosopher. He has such a rich experience, and we always invite him to be a part of our webinar. So Mr. Bala, welcome you also. So yeah, without taking much time, I'll request Mr. Bala to take over.
Good morning to all of you. I really have a great pleasure in welcoming you all on my own behalf and also on behalf of Mehta Mehta. Today's subject is a little away from our usual company law or other related laws, because this particular subject is the one day in and day out in any organization, whatever you call it, we are dealing with, really speaking. Because this is related to the human beings. Because when you take up the job, you are governed with the labor, you are governed with the contract of employment. Let it be an office, let it be a stop and establishment place, let it be a manufacturing unit, any place. Ultimately, the terms and conditions, the appointment letter or employment contract, whatever you call it, that is what it starts with actually. And second thing is, government is very concerned. The people who are working any places, their interest should be safeguarded and their well-being is taken care of. Some safety health arrangement is looked after. Working environmental is actually better, and they are actually getting the compensation, etc., to the level which is actually expected. That is why we all have studied in our CS course almost more than about 3 dozen labor laws we have studied actually. Starting with Payment of Wages Act, and then Compensation Act, plus Industrial Disputes Act, plus Gratuity Act, plus Retirement Benefit Act, plus the Maternity Act. So many acts we have actually studied in our curriculum also. But unfortunately, this particular area, which is open for a very vast scope for the practice, it is very less number of people who actually like to take up this case. In fact, our institute, when I was in CCRT as a regular faculty, we actually brought up a booklet on labor laws, the opportunities which are available to the company secretaries way back in 2015. And thereafter, the Institute of Company Secretaries also brought out a booklet to the benefit of the members, the areas which are available, highlighting the various things, even checklist, etc., which are actually built in actually. But today, what has happened is in the recent past, I think Mr. Shantanu will be addressing that. Almost all the labor laws have been now brought out in the main headings. Very recently, the 29 labor laws have been actually classified under 4 different labor law codes. That is what they have done. So what happens is the labor law not only talks about the employment, but also talk about various other things. Safety related, health related, welfare related, equal remuneration related, equality related. And again, we have a male and female. They have the certain restrictions for the female and taking care of equality, all those things. So it all talks about everything. So when it's come to that level, really speaking, there are n number of compliances which are actually required. Understanding the concept, ensuring the compliances. There is a periodical compliances, monthly compliance, quarterly compliance, half-yearly compliance, annual compliance. In addition to that, there are inspectors who are actually appointed. Now we are all aware, we are actually moving to the digitalization era. So everything is on digital, everything is open and transparent and disclosed. Gone are those days, inspector used to visit the factories, and there are a lot of people who will manage the inspector. That concept is more or less now gone actually, because now everything being the online, it is actually visible. They can take away inspection itself was on online. What is done, what is not done, what is the thing, that is one. Second thing is, even if the inspection takes place also, there is an obligation in the law. Whatever he has done within the time frame, I think it is within 2 days or something like that, he has to actually upload the entire details on the online, which is visible to everybody. So that is what the digitalization actually taken us. So with the result, what happens? A lot of enormous things each and every company need to comply. It is more so in respect of the manufacturing organization. Lot of company secretaries are actually employed in the manufacturing organization, even in the other organizations as well. So naturally, the people who are employed, they can definitely bring to the notice of the people, the top management, what are the complaints, what are the things, what is to be done, etc. What is required to be set right, all those things. He can definitely bring the updation, etc. Another thing and all one hand. Second thing, there is a lot of things which need to be done. Any law you talk about it, first thing is start with the registration. Second thing is maintenance of the records. Third thing is various regular payments, monthly, or quarterly, hourly, annually, whatever it is, and plus submission of the various returns and various things has got to be ensured. All those things are all actually involved around. In which case, the company secretary can definitely do a lot many things. It is a very wide area which is actually open for the practice. And the main thing is what happens is if something goes wrong, the litigation process. I do not know how many of you are aware. There are n number of litigation cases are actually pending in the labor courts even today. N number of cases. Because you would not have forgotten what happened in the year 1984 when the Bhopal gas tragedy took place. When the Bhopal gas tragedy took place, the people who are in and around north, they will be knowing Bhopal especially. The entire city is actually gone. Now they have created what you call the new Bhopal. If anybody says that I am coming from Bhopal, I will ask the first question, are you living in the old Bhopal or you are living in the new Bhopal? That is what the first question I will actually ask. Because I happened to visit the Bhopal in both the times. And in that particular case, what has happened is n number of people who have suffered. There are a lot of things which actually came out. Ultimately, the chairman of the union corporate who was there, he was actually imprisoned for a period of 2 years, the prosecution. That was the result, which has ultimately resulted in that case, apart from compensation, levy, penalty, etc. and other things and also see. That was a great thing which has happened in the year 1984. Then later on, what happens is people try to take various things and they started appointing the namesake somebody in charge of the factory or something like that. That was also going on for quite some time. But the government is actually wise enough to realize this. In the year 1996, there was a landmark judgment which came from the Supreme Court of India. That is a very landmark judgment which actually spelled out very categorically, stating that there has got to be an occupier of the factory where the manufacturing units are actually involved. Because we may be knowing there are multinational companies which have been centralized, situated at a metro city like Bombay, Pune, Delhi, etc. But they have the manufacturing units scattered around across the country in many places. Now, who takes care of the things which is happening in the remote place and the factory? They used to namesake appoint somebody, and they used to get away with them by naming them is responsible and other things. But the Supreme Court judgment has said nothing doing. It is ultimately the responsibility of the person who will be named as an occupier of a factory. The occupier of the factory can only be a director. That too also the whole-time director, he needs to be named. If none of the people have been named as the occupier of the factory, all the directors will be deemed to the occupier of the factory. They will be wholly responsible for that. That is the judgment which has come in the year 1996. Thereafter, many things have actually changed. You talk about the working environmental, you talk about the safety health related issues, you talk about the maintaining the place, etc., providing the facilities to the people, working hours, overtime regularization, treating the people equality of the employment. All the things actually come up very much. And today we are in the era of the combined courts, which is basically 4 courts which have come combined, as I said, around 29, 28 or 29 laws have been combined to the 4 courts, which actually spelled out various things. There are a lot of terms have been redefined. There are a lot of compliances has been put. Now we are actually decriminalizing towards fine and penalty, but fine and penalty are very heavy nowadays. Of course, the prosecution is going to be there. That will be cannot be eradicated because prosecution will definitely be there for take the bona fide intention and illegal activities, and the people who are deliberately doing it, they will get definitely punished. But apart from that, whatever the non-compliance is going to attract severe penalty for the senior management, especially the directors and the senior managers of the people in the organization. That is the challenge what we have. Really speaking, there is a very good opportunity for the people who are working in the organization to ensure the compliances, educate the people, do the things. Second thing is for the practice, there is a wide area is open for the practice in this, which I would say. I was fortunate in handle many labor related issues in my time in the company, because the company where I was working, you know that we were working in the license Raj those days. In the license Raj means you cannot expand in one particular place, you have to go to the remote places, you have to open this monopolistic and trade activities, etc. and other things are all there. Those days, our company where I was working, they opened the units at a place called Pondicherry and Jamshedpur and Jammu and Kashmir and Calcutta and other places. And suddenly one fine morning, everything has changed. Liberalization, globalization, privatization. There is no more license Raj. Everything can be done at one place. You need not have all this thing. So everybody started consolidating, closing down the units, and they're bringing back one centralized unit. This company was also not exception. They started closing the units. They actually had about 5 manufacturing units. They closed 4 manufacturing units. They opened one more manufacturing unit. That means what they have done is 5 minus 4 plus 1. That is what they have done. In the process, there are a lot of issues going through under the Gratuity Act, Provident Funds Act, and Industrial Disputes Act, Roads of the Factory, so many litigation which actually came. I was actually fortunate enough to handle all these issues in the company. I know what is the depth of the industrial labor law. Not only that, we are all good because our first topic in the initially when start learning the companies, our course, CS course, we actually start with the Constitution of India and the interpretation of the law section. In Industrial Disputes Acts, if you want to go through it very carefully, there are various places what you call and or it is used. Where it has to be interpreted and is applicable, where it is or applicable, where both are applicable, where one is applicable, where it is read singularly. That is actually a great task. We are all being the people who are well versed in the corporate laws. We should be in a position to interpret correctly, advise accordingly. That is what it is required. So with that background, I hand over the mic to Mr. Shantanu. He will share few things on about the topic, what he's going to take us through, etc., and other thing and all, and he will give us a presentation on this, and we will come to know the various challenges coupled with the opportunities which are available to the company secretary, which they can excel as one of the practice area in the future days to come. In fact, as I mentioned, there are backgrounders and booklets are available from our own institute on the labor laws, which is actually there. You can actually purchase it from the bookstores, etc. It is available. You can also go through. That will also act as a guide to you. Thank you. Over to Mr. Shantanu, please.
Thank you, Bala sir, for sharing your rich experience with us. And now we will move to our presentation of today's presentation. I would like to share my screen. So if you are able to see my screen, you just let me know. Yes, that you are able to.
It is very much visible.
Yeah. So I have prepared this presentation basically, and it is the title. You can see that the challenges and opportunities under new labor laws. So basically, I am doing extensive research nowadays on these new labor codes. And there is a reason for that, because I was working for in this matter on this labor laws, existing labor laws. And there were so many people on my YouTube channel. Actually, there are so many people, they got connected to me, and they liked my videos basically on labor laws. And they asked me to, sir, please, if you can provide the content on new labor codes also, because new labor codes are there and they will be applicable most likely next year. So I thought that it is the right time that we should do the research. And for company secretaries, what I feel, it is very, very important topic for all the company secretaries. And I will show you why this is so important for each and every company secretary, whether in practice, whether in employment. For every company secretary, there is opportunity, lot of opportunities, as well as there are challenges also. We will see those things in the slides. But one thing in the presentation itself, I will like to ask you, after introduction of MCA portal, as we are all company secretary, majority of us are company secretaries, have you seen any changes in level of compliance, the transparency, So I just want to know from all the audience whether you have witnessed, because I have certainly witnessed that, because pre-era, I mean, before MCA portal, I have seen how we used to work, and now it is totally different. So it is totally transparent, and the compliance level has increased manifold. Now, this labor law, you can say that it is in the concurrent list. First of all, many of I think everyone will be aware of that. It is a concurrent list matter, and both central and state governments, they are entitled to make laws on these subjects. And in past, there were so many laws, state laws, almost 100 state laws, and almost 44 central laws, and it was very, very confusing. So many terms were defined, different act differently. So it was very confusing to comply the labor law. But now this government has done a tremendous job that they have brought these new labor codes by replacing all those 29 labor laws into 4 labor codes. And so multiplicity of definitions are now being avoided in this new labor codes. And it is very, very, I can say, much more easier for professionals to, understand all these laws and comply these laws for the company. So we are going to see all these things now. And let me begin with object of this presentation is to focus on challenges, that is in implementation, and opportunities, that is in practice area, even in jobs, we can say, under new labor laws. Okay. So there are so many challenges. Implementation, when I say, then I mean to say interpretational issues are there, which will be sorted out. And I will tell you how things will move from here onwards. Now, now the most important thing which you have to remember that people like company secretary is a key managerial personnel under the Companies Act, and he's required to comply the law wherever it is applicable to companies. Now, there are 4 new labor codes which are being introduced now, and you will see that in each code there is a provision of offenses by companies, and I think everyone must be, as a company secretary, you must be aware that if the offenses by companies, so there will be some, responsibility comes on the shoulders of the company secretary as well. So here is the provision. Almost in all the codes, it is written that whenever there is an offense which is committed by company, and it is proved that the offense has been committed with the consent, conveyance of, or is attributable to any neglect. I'm highlighting the word neglect because it is very important for us company secretaries to understand. Neglect on the part of any director, manager, secretary, or other officer of the company. Such director, manager, secretary, or other officer shall also be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. Now, as far as labor laws are concerned, in the past, the overall burden of labor law compliance was, what I have understood till now, was on HR department and somewhat a consultant. That's it. No person was fully responsible to comply. They were taking the help of the consultant mainly, and this is the position till now. But now things will change, and I can tell you that company secretaries will have to play a crucial role in this, because company secretary should expand. And the labor law is really so vast. It is not restricted to companies. It is it is beyond that. I mean, industries and firms and everywhere.
Especially after the Companies Act, which came into force in the year 2013.
Yes.
The section 206, which talks about the functions of the company secretary. It is very categorically mentioned the company secretary has to ensure the compliance of the Companies Act, and also see the compliance done in respect of all the other corporate laws which are applicable to the company.
Yes, all the laws which are applicable.
The company secretary has been made responsible for ensuring the laws with the help of the management. Though he may not be the person who will ensure himself, but he has to see that it is ensured. That responsibility has been actually now casted upon to him under the Companies Act itself as a statutory duty.
Thank you, Balakrishnan.
Naturally, he cannot escape here, and especially in the new law, his name is also has been spelled out very categorically.
Yeah, so it is a double proof. We can say that Companies Act is also specifically stating that, and in the labor laws itself, in all the codes, secretary is named there. If anything goes wrong, if there is a neglect. Now, I'm coming to the neglect part. See, management, wherever, so suppose a company secretary is working in a mid-sized company. I'm not talking about a huge company having huge resources. I'm talking about a mid-sized company. A company secretary is working, and the directors of that company may be busy with their businesses, handle the business. And HR manager is also not that much equipped. Try to understand, in a mid-level company. So company secretary, if he is there, it is the responsibility of the company secretary that the company secretary should brief the management about these new labor laws. And from the day one, the company should be able to comply regularly. Because what happens in law, there is a problem is that if you make a default once, एक तरह का दाग लग जाता है shirt पे, and it will be highlighted in the audits, and the reputation of the company will go down. Company suffers a lot. So proper awareness is very important for all the company secretaries, and I request all my fellow, brother, sister, professional, that management may not ask you. What I have seen in the in my experience in the company, management may not approach you to seek help on these matter, but as a duty, our duty, that we should brief the management about these new labor laws and tell them that this is very important because it will be fully transparent now, and there will be the prosecution and everything is, lightning speed, everything will be happening. So I'm just giving one example as far as all the company secretaries are concerned. Example one, why we should be ready with these. Every employer, now, as per the new law, every employer shall issue wage slips electronically or otherwise to employee in the form 5 on or before the payment of wages. I just want to know, because I don't know in your companies whether you are getting the wage slip. Maybe a big company, you will be getting the wage slips before, on or before the payment, because the person who is going to receive the payment should be aware what are the deductions he has made, and if anything goes wrong, he should be able to report. This is professionalism, I can say. It is professional practices. The government trying to guide us that try to follow these things. It will, develop a good culture. It is all about culture, developing a culture. So how many of you and your companies are issuing such wage slips before, on or before payment? We have to ask ourselves. And if it is not happening, then please remember that you should make a checklist, because I will be there, like all of us will be there, and we will develop some checklist also, that every company secretary should try to ensure that all these points should be met in respective companies. Now, this is the example one. I'm trying to say that you have to comply such little things also. Example two, every employer shall display a notice on the notice board at a prominent place of the establishment containing the abstract of this code. Now you can see that I think company law also talks about the name and address of every company should be mentioned at every establishment or something, but there is no inspection normally. But here you may find that there will be a regular inspections, and if you get caught, then it is a penalties and prosecutions and image, everything will be affected. So try to understand that abstract of this code, category wise wage rate. I will talk about this category wise wage rate of employees' wage period. What is the wage period? Day or date and time of payment of wages. And now this is the most important part. You have to mention on the notice board of every establishment. If you are a company and you are having 5 establishments, every establishment should show all these things at the notice board. Name and address of the inspector cum facilitator having the jurisdiction over that establishment. So this is really very important things, that minute things which we should note. And if we don't comply, then it will be, problem will start. That's what I want to tell everyone.
There is one question has actually come.
Sorry?
There is one question is actually asked by the participant. Virendra is asking.
Okay.
Is there a difference between the wage and salary under the new code?
Yeah, very good question. Actually,
or by referring wage, are we relating only to the laborers?
Very good question. Even there are so many questions which comes into my mind also, but I keep in that, and I'm doing research on that. See, wage is basically properly defined in the codes, and I will tell you about why they have defined that. Salary is the basic term. They have not defined the salary, they have defined the wage. Now they have named it as a wage slip, but actually it is a sort of salary. We will see the form 5, where you will be able to see what are the deductions being done and how much payment is being made. So basically wage is a different and salary term is a different. I will come to that. And as far as this nomenclature, what they have named wage slip, what I feel it should be salary slip. I think I have answered your question, or still you want clarification?
No,
Then,
when you go for the wage slip, we can know the more answer of that.
yeah,
And somebody has actually shared, when you say the wage slip is whether made available or something, Rajendra is saying, generally in the mid-sized companies, it is on demand. I think he'll put a remark on that. And then there is one question has come from Richa. This inspector cum facilitator should be a employee or external agency for the company. I think the inspector and facilitator is actually appointed by the government, not the internal person.
Yeah.
It is the government person who is actually responsible for that, who is designated for that particular unit or factory, whatever it is, that is the person. Yeah.
Yeah, let me clarify this point. Inspector cum facilitator, for those who are totally new to these new labor laws, Inspector Raj was there earlier. Okay, earlier Inspector Raj, inspector used to visit the factories, and there are so many things he used to inspect in his own way. Now the term has been changed, the nomenclature of the inspector cum facilitator. So it's a government servant, and his powers have been curtailed tremendously. Now he is more, responsible, and he cannot visit at his will. He has to take the permission, and as per the scheme of inspection, only the inspector cum facilitator can visit. Why they are asking us to mention the name of the inspector and facilitator here? Because any employee can approach the person. Okay, that is the reason they are asking all the establishment to mention the there. I think question is clear, or if you want to ask, you can ask. I mean, digitalized, the environment will be totally digitalized. I have already asked you question. MCA 21 has changed the, the way secretary used to function, at least what I have seen. Everything is digitalized. I remember that when I used to go to the registrar of company's office for inspection of a file of any company, I used to wait for 1 hour, 2 hours, because the person has gone in the room to search for the record, and after that 50% chances he comes that record not found, it is not found. So we cannot do. Now everything is online. I think you can see yourself digitalized. This labor laws is also going to be in a digitalized environment. And remember, both way it will happen. Like for companies, it is better to easier to comply, and for employees also, it is very easier to raise the dispute and complain to the authorities. So both ways it will be very fast. So company secretaries will should be aware of this fact that if we don't comply the law, anytime anything can happen, because it is very fast like electricity. So this is very important concept. Now, as far as code on wages is concerned, I just want to give just a total picture of code on wages, just one code on wages, so you will be able to understand the other codes also. See, if this is the screen, you can see that there is an establishment in yellow, and there is an inspector around establishment. Employees are there and trade unions are there. So how many of time, because I have received so many calls during last 6 years or so, because so many people used to call me from different locations that we have not received our wages. I mean, salary we haven't received, what we should do. Now, try to understand that if you delay the payment of wages or like salary, then any of these can complain to the authority. Okay, everything is given, format of claim, everything is given. It will go to the authority, and authority can pass the order. And even the person can go to the appellate authority. Now try to understand one important thing here is courts are outside now. This is specialized, bodies have been framed here, bodies are formed here to handle these matters here in the department itself, in the act itself. So the person need not to go to file a civil suit. Try to understand, everything will be very super fast. I hope you have understood that even the labor courts earlier used to court of inquiry, everything has been abolished now. It is not there in the new system. Everything is internal system is there. So justice will be done very quickly. Now, as you must be aware, being a company secretary, whenever new law.
Shantanu, 1 minute, See,
Yeah.
what is happening, I've seen in my, last 20 years, like normally the employers hold the salary because the employee has left abruptly. And so, it is typically they just put down their paper and, in 2-3 days, they are just, disappeared. And so ideally they are supposed to give a notice. Now, in these circumstances, the employers hold the salary. Now, at the same time, your employee expect, okay, look, I worked for 30 days, but, and, you have to pay me the salary. Now, in that scenario, because, as per your appointment letter, you are supposed to give a 30 days notice. So now, see, for all purpose, the employer is right in his perspective because the employee has abruptly left, and this caused a lot of problems to the employer. Now, whether the employee is justified to ask for the salary?
You want to say, what I have understood is that suppose employee is not coming, he has left, he's not coming, and there is no notice period served, I think, from either party, and he has, see, there are certain other provisions, sir, for if he is not coming, you can deduct the wages like that extra, but you cannot hold the payment. That is for sure, because whenever labor laws, you can assume that they will be tilted towards in favor of the labor. So in this case, things you will see that company cannot hold the payment. Even the provision says that if a person is, leaving the job, retrenching, you are retrenching, or anything happens, you have to settle the whole amount immediately. I'm coming to that point. I will come to that point also. Law is so strict now. This is the thing now.
So, unfortunately, in this country, the system which is working is actually of the pro-labor, and they always look upon an anti-employer. That is what the mindset is there all along. Atul, to answer your question, we had a situation. The person has not left abruptly. Person has actually given a notice. But the problem is, he was actually a branch manager working in a different place. And he is supposed to give the notice to the head office to whom he is reporting. And the company has actually provided him certain things, the company's assets actually. He has been given a motorcycle and he has been given some fax machine, etc. those days to operate. Plus the computer was actually given to him and some table, chair, furniture, which are all were there. So when he served the notice, company told very categorically, please return all these assets, obtain the receipt so that we will settle. You get me the settlement letter having returned that. That fellow behaved very funnily. He said, no, unless until you pay me the salary, I am not going to return this. He was actually withholding these properties. So in that case, what has happened is, although he tried, we actually filed the case. It was in the 1956 case, you may be knowing, section 630, where we can say the unauthorizingly withholding the company's properties. We have filed the case against him. That too also we have filed the criminal case. The matter went to the court. After matter went to the court, in fact, before that, I called the employee. I talked to him. He was in friendly terms with me. It has happened in my own company. I advised him 2-3 times. But some consultant was driving him. No, you do that. Nothing will happen. I'll take care. It is again, the consultant, they want to make the money. So that is what it has happened. Finally, when the police people landed into his place and he has been served the notice, and he has been told that he will be actually taken for the custody, that is the time he realized what is to be done. Then again he spoke to me. I told him, even at this stage, you can wake up. If you return that, okay, we will stop the action. Otherwise, it is going to happen. That is what it has happened actually. So there are records is available, as Shantanu has puts it. there are some other resources which are actually available, but will depend upon the circumstances to circumstances that we will have to take a call. But anyway, all said and done, the judiciary is more or less, the mindset of the government is actually a pro-labor. And mostly, if we go, even if you are greatly right also, they always tend to favor the working class. That is it.
But in this new labor codes, I think government has tried its level best to, to provide the level playing field to both employer and employees. I will come to that also. And these, whenever new law is born, I can say it is a baby like in the womb. There will be so many things which we would like to highlight that this should be like that. And I'm coming to this point. The government was totally aware of this fact that whenever this will be rolled out, there will be some problems. So the power of government, so all these four codes have given the power to the central government to remove the difficulties in case if there any confusion or there any problem regarding some minor changes. So government can issue the order and can rectify the things. Interestingly, this power will be with the central government to rectify this, so no need to go to the parliament for approval. In Code on Wages and Industrial Relation Code, it is for 3 years from the commencement of the codes. And for OSH and Social Security Code, it will be 2 years from the commencement of the code. So government, actually, there are so many things which we have to work now. What I feel, we have to do the research and we have to submit to the government that these are the things which you should consider. That is what I feel. And there are things which I am, already noting it down. And I would like to, hand over to the even institute or the department that these things should be, rectified. So there will be always scope for improvement. That's what I feel. New labor laws. Now we will talk about the structure, applicability, key concepts, and practice area, because it's a huge area. Try to understand this, because company law is definitely a main area, but this will give additional, avenues for company secretaries to venture into this field. So first we will talk about the structure. As Mr. Bala has already pointed out, that 29 existing labor laws have been subsumed by 4 new labor codes.
One more question has come actually.
Yeah, please, sir.
In the context of the display of the notice, as referred in the previous slide,
yeah,
would be the place of the establishment cover only the factory or even the branch office, corporate office, or head office, etc.? Because when we refer to the wage, there may not be any wage in place other than the factories.
No, establishment is properly defined in the act, in the code, and we have to, suppose we are having 5 establishment, for example, there may be a trading shop, store, there may be go down, something like that, place of trade. I will come to that. So everywhere establishment wise, you have to affix the notice. I think I have answered. If any queries there, I will still be there to answer. Every establishment wise, you have to affix the notice, because the inspector may be different for different establishments.
Even to answer your question, even in the earlier act also, when we had, the branch offices and other places which are actually covered under the Shop and Establishment Act, we used to get a shop and establishment license, which is really required to be properly displayed, which spells out the name of the person who is responsible, which are the areas, what are the things, etc. That is always there. In a conspicuous place, it needs to be displayed actually. And we have been doing it also, because we had around 32 branches at that particular time when the license Raj was there. So that was actually there. It is required, not only restricted to factory, it will be for all the establishment.
In the
new labor code, it is there like that. Yeah.
Yes, I think point is clear now. So these are the 4 new labor codes. Codes on wages 2009. First, it was passed in 2019. Then Industrial Relations Code Occupational Safety, Health and Working Conditions Code 2020, and Code on Social Security 2020. So I have given the in brackets the number of acts which this code is going to replace. For example, Code on Wages, it will replace 4 existing labor laws like payment of wages, minimum wages, equal remuneration, payment of bonus. So these 4 existing laws will be replaced by Code on Wages 2019. Similarly, IR, I will name it like IR will replace 3 laws, and OSH will replace 13, and Code on Social Security will replace 9. Now, this is a very interesting point which I want to highlight, that these 4 labor codes together is as equal, as big as company law. So it is a huge area which the company secretaries can explore, and it is as good as company law, as I can say. And there is a lot of things to be done. I will tell you slowly, you will come to know about that. So there are total 480 sections combined together, 331 rules, and 18 schedules, forms, number 61 forms are there, and total 222 definitions, out of which there are a few definitions which are very important. So all these we have to understand to comply these new labor laws. Now, in brief, just I will come to that. Code on Wages, 4 labor laws will be replaced, as you can see in the screen. IRC, Industrial Relations Code, will be replacing trade union, standing order, and industrial dispute. And after that, OSH, main act was Factories Act, you must be aware of. Factories Act will be subsumed by OSH. And there is another main act, if you talk about another main act, is Contract Labor Regulation Abolition Act, and interstate migrant worker, and all these laws. So other, small acts, but majorly you can talk about factories, and contract labor will be subsumed by this OSH. Now, as far as Social Security is concerned, all acts are on the screen itself. Employee compensation, employee state insurance, provident fund, employment exchange, maternity, payment of gratuity, then senior worker, building and other construction, and Unorganized Worker Social Security Act. So I will come to that. So these are the basically law. It will be replaced by the Code on Social Security. Now we will be talking about the applicability of these laws in general. Okay, there are a lot of ifs and buts, but I will discuss it later on. But on an average, you can assume that Code on Wages will be applicable universally. Everywhere Code on Wages will be applicable. Employer of every establishment will have to comply the Code on Wages. So establishment means what? A place where industry, trade, business, manufacture, or occupation is being carried out. So even a kirana shop, grocery shop, you can say, it is also employer will also have to follow this, provided there is an employee. Actually, if a person individually handling the shop, then there is no problem. But if there is an employee, then the employer will have to follow at least Code on Wages. We may not talk about other, but even the smallest establishment will have to comply the Code on Wages. Now, as far as bonus is concerned, because the Bonus Act is also subsumed by the Code on Wages, as far as bonus is concerned, it will be applicable to only those establishments where 20 or more persons are employed on any day during preceding 12. So this, you just have to remember this particular thing, that bonus will be applicable for bigger establishment, and rest minimum rates of wages or everything, payment of wages, equal remuneration, everything will be applicable universally. Any question on that? Okay. Now, applicability of Industrial Relations Code, we will come to that. See, industrial relations the most important thing you have to remember that it is not establishment, it is industrial establishment. Wherever there is an industrial establishment, IRC will be applicable. Okay. So wherever industry, now industry, we have already seen so many case laws are there. There is a systematic activity with them, cooperation of employer and worker, production, supply of goods, services to satisfy human wants. Now, the very important thing which you have to remember, because this IRC deals with strikes, walkout, retrenchment, everything will be covered by IRC. So you have to remember that it will not apply to charitable, social, philanthropic organizations like establishments or summoning functions of government like defense, space, atomic energy. No strike, no lockout, something like that. Nothing will happen. The provisions will not apply. Even on the domestic services, it will not apply. Domestic services where you hire for your own home service.
Sanjeev Kumar is asking a question.
Yeah, please, sir.
Any threshold limit applicability of the new code?
Any threshold?
Limit applicability in the new code.
New code for industrial relations you are talking about, IRC?
Sanjeev, I'm not very clear in your question. What is exactly in your mind, please? Can you speak, Sanjeev? Threshold limit you are talking about in terms of employee or in terms of anything or any particular code?
Yeah.
Yeah, Sanjeev, are you there?
I think I got the question.
Acha, he is asking number of employees.
Yeah, number of them. I got this is a basic question actually. A legal person actually should have in his mind. Now try to understand the provisions related to retrenchment, strikes, everything. It should be applicable everywhere. I don't know. There may be some changes later on. Okay, but things are not clear. So for the time being, they have just kept out charitable, social, philanthropic, sovereign functions and domestic services. What they have done, I will be clarifying you with some more points. There are certain special provisions. Try to understand these things. I think these 2 points are very, very crucial. If you are able to hear me, these 2 points we have to focus here. Chapter 10 is applicable on mine, factory, and plantation. Okay, mine, factories, and plantation only. No other, like if a person is having a software company, it will not be applicable. Try to understand. Any other establishment, it will not apply. Now, what exactly chapter 10 talks about? The chapter 10 says that if you, that is the establishment, want to retrench any layoff, provide layoff, retrenchment, or go for closure of the establishment, then such establishment should take the prior approval of the appropriate. Try to understand. This is very important limit. That earlier limit was 100 and now limit has been raised to 300 workers. So there is no need for government approval for layoff, retrenchment, or closure to any industrial establishment which is having less than 300 workers. Are you getting my point? It doesn't mean that you don't have to pay the retrenchment compensation and everything will be same. Like you have to pay the retrenchment compensation, you have to pay for the layoff, closure. The only difference is that you need not to go for the government approval. I think, have you understood this? Because I can explain it in detail also. Earlier, what people, I mean industrialists, they used to do, because the government interference, because of the government interference, after 100 employees, the industrial establishment, they used to divide. The industrialists used to divide the industrial establishment, not exceeding 100, not allowing exceeding 100 workers at any establishment. So he need not to go for those government approvals or for retrenchment, layoff, and etc. But many state government has already increased this limit to 300. So government actually wanted uniformity for government approval. So government has done that. It should be 300 limit. If the industry's establishment is having 300 or more, then only government approval is required for retrenching, a layoff, or closure. I think you have got the point, Mr. Sanjeev. If you have still question.
Yeah, it is again, ease of doing. It is actually a ease of doing
Ease
business.
of doing, yes.
Unnecessarily getting away the bureaucratic things of getting for everything depend upon the government approval, etc. But at the same time, as you rightly said, the required compliance have to be met actually.
Yes.
Even
So
though there is no government approval.
Yeah, rightly said, sir. No, the employee will get their dues. Only the government interference was there. And that has been extended like up to 300. You have to take the approval. And I think it is ease of doing business. Now industrialists will be able to employ more and more people in the establishment. Try to understand. So it is a good sign, and there may be more and more employment. So it is a fire policy up to this limit, but it is good for ease of doing business, and it will also attract foreign capital. That's what I feel sincerely. Moving on now, standing orders. Standing orders will not be applicable to less than 300. Again, the standing order certification of standing orders, which we have to, used to do. No government approval is required for standing order if the number of workers are less than 300. Again, the government interference, it was earlier 100, and now it has been raised to 300.
It's a very, very good welcome move, because I know getting the standing order approved over the government itself is a big.
I know, sir. Even in ROC sort of thing, change of name or something, like you have to visit so many times. Now the thing is,
welcome things, and the companies are equally free to frame their own standing orders, of course, subject to within the framework of the law. And it is a very big headache they are removed by this.
Yeah, and actually they have also provided that they will be framing, the government will be framing the model standing order, standing. And if any establishment is not adopting its own, modifying anything, so it will be deemed to apply to that establishment.
That is
it is ease of doing business. If you want to change, you go for certification. Otherwise, be happy with the model standing order and do your job. I think it is good.
Sir, I've handled one cases where the local political party gets into it, and once they get into it, the life of the employees gets very worse and miserable also. So I think this is a very welcome move, and I also support views. Yeah, thank you.
Yeah, it is really nice move actually. So that is what I say. I was saying that is a level playing field. Applicability of code on social security is a rough figures I'm giving, Sanjay. I mean, if you are there, try to understand. Here limits are prescribed clearly. The provident fund will be applicable only if your establishment is having 20 or more % employed. State insurance, gratuity, maternity benefit 10 or more, and employment information 20, that is employment exchange. You must be aware that if there is vacancy, you have to report that. It will be applicable if there is 20 or more % employed.
Now, I have one small question here.
Yeah, please, sir.
I remember in olden days, I'm talking about, 60s and 70s.
Okay.
When digitalization was not there, computer was there, it was only typically a typewriting era.
Yeah.
And, many of the young youths, after passing out their matriculation, etc., and all, they used to walk away to the employment exchange. They get registered their name in getting the employment. They used to get the notices issued and other thing and all. That used to be the recruitment procedure which has been followed. Even I have seen this employment exchange functioning till late 90, 95 also I have seen. But after that, I do not know, with so much of, employment, digitalization, the consultancy agencies, and so totally the process is actually outsourced, etc. Is there a field is played by the employment exchange? If there are employment exchange in existence, are they working?
Actually,
Or
I'm telling you, I'm giving you answer.
Yeah.
You must have seen the post office today's. Nowadays, post office, how they look like.
Yeah.
So actually, now there are so many people who are going to job agencies and they are placement agents and so many things. The people are not looking at that. There is a legal provision. Even I was studying this law when I was a student of company secretary. I was wondering, is anything such type of thing actually exist? So there are, certain laws which are good, but not, complied with many companies. I think so. But
no,
now,
in fact, I remember in somewhere middle of 70s or something like that, we even got a notices from the employment exchange that you are not notified the vacancy for filling out of your filled without our intimation. Why don't you take a show cause notice and we are giving explanation what made you do, why action cannot be taken? Such notices have been received actually in an organization where I was working. So
but,
that is why I'm asking this question today.
no, but sir, which year you are talking about?
70s, mid 70s. Yeah.
Okay, before I born. So actually, it was a different era. Actually,
That is what I said. It's a olden time. So I'm comparing the olden time versus modern time. Is there a role today? Is there anything? Because if you ask many of our youths today, they even may not be aware there is an employment exchange is actually there.
yeah, actually, when I was studying this employment exchange chapter when I was a student, I thought that it is so good. I mean, it was good for everyone, like for industry also, but somehow it didn't work actually. But now government is reviving it. But because now it is information technology, government can take the data and immediately people can understand that where are the vacancies, and the employers can also post the vacancies very quickly. So it is a revival, you can say, of this.
Deepak is asking state insurance coverage for ton. Who falls under ESIC ceiling limit or total strength, including exempted wage also?
You want to know about the state insurance, who will be covered under the state insurance, okay? The wage limit and everything you're asking. I think government is going to come up with all these things. For example, for payment of bonus act also, government has to decide the ceiling limit up to which the employee will be eligible for that. So still there are a lot of things which will be clarified in time to come before these laws are implemented.
Yeah, today actually it is not clear. It is not spelled out actually.
Yeah,
this is the premature stage, but today we do not have the details on this exactly, except that the number is only available.
Yeah,
so the ceiling limit,
available.
etc., is yet to be notified actually. Yeah.
Yeah. But I am doing extensive research. I'm in middle of it, and definitely I will come up with a lot of new things, and I will let you know about all those things. Then there is a cess actually, building and other construction worker. There is a cess. It used to be there, and now it is there in this code on social security. So establishment, whoever is falling under building and other construction work, we will see the definition. It's a very big definition. We will see it later on because time is not there. So we will cover it later on. Then social security for unorganized worker. Now this is very major, boost, you can say, for the unorganized sector, that government is planning, although there was act, but government is planning at a bigger level to provide social security, social cover to unorganized sector workers of unorganized sector, gig worker, platform workers. These are the new terms which they have introduced, and we will see all these in detail later on. So unorganized sector is being covered. And I have noticed one slight hint that CSR provisions, you must be aware of CSR, companies have to spend 2%. And government is now planning to, take some amount, most likely the 1%, that is half of the CSR. The government is trying to pull out from there and will provide some social security cover to unorganized sector. But this is my feeling because I have gone through. So it is going to happen. Applicability of OSH code, every establishment, which is now here, the numbers are specifically mentioned. Let me just finish the 10. It is a number is 10 basically. Now, this is a very important thing which you have to understand. OSH means about factories. Okay. OSH about factories, and OSH.
I think OSH stands for Occupational Safety and Hazard.
Yeah. The major factory act, the factory act was the major act, which is going to be subsumed. So when we think about OSH, we think about factory. And so try to understand OSH is very, very important act out of all these three. And it contains annual return also, which will be, for combined one single annual return you have to file for all the three codes, compliance of all the three codes, and which is mentioned here. And the establishment, they have defined that establishment need to be registered. So place where any industry, trade, business, manufacturing occupation is being carried on with 10 or more workers where are employed, or motor transport undertaking, newspaper establishment, audio, video production, building, other construction work, plantation, with which 10 or more workers. Why I'm telling you specifically, because this is a big and you have to focus very carefully here. It is very important point I'm going to tell you. Factory, for the purpose of chapter 2. Now, chapter 2 is talking about the registration of establishment. The first thing which comes in our mind, sir, we have establishment, whether we should register. We are manufacturing, whether we should register in OSH, because our although we are not a factory. So try to understand that clearly. They are saying that as far as registration is concerned, registration of factory is concerned, 10 or more worker, if it is there, forget about with power of aid or without aid of power, forget about power. If 10 or more workers are employed or are being employed in that place, which will be treated as factory, and it should be registered under the OSH code. Are you getting this point? Because it is very critical. Earlier, let me explain you the earlier position. Earlier, the factory means where 10 or more workers are working
with the aid of power.
Yeah, with the aid of power, and 20 without aid.
Yeah,
it was the definition of factory. But now they have doubled those figures as far as provisions, applicability of, because factories provisions are very dangerous. They have doubled that figure as far as provisions, applicability of provision is concerned. Now the factory is where 20 or 40 workers are working with or without add-on. Okay. So for registration purpose, if 10 persons are there, you just remember 10 persons are there, then you have to register under OSH. I think you must have got this point. Mine, port, vicinity, or port where dock work is carried out. Now, mine, port, and vicinity of port where dock work is carried out, there is no limit. So even you are having 5 persons, you have to register under OSH. Are you getting my point? In case of mines. Now, the threshold of workers specified not be applicable in case of specimen class specimen in which hazardous or harm. Now, again, coming to the hazardous process, if there is any hazardous process, life-threatening activity, they are saying, then 10 will not be the threshold. It is even one person is employed, you have to register under OSH. I think this point is clear to everyone. So if it is hazardous, life-threatening, you have to compulsorily register. Don't look at the number of workers. And if it is mine, port, or vicinity of port where dock work is carried out, don't see the number. Any other establishment, you just see the number 10. You have to register under OSH. Now, again, coming to certain exclusions for as far as the registration of OSH. Does not include mobile unit belonging to armed forces of union, okay, railways, running shed, or hotel. Hotel, restaurant, eating places need not to register under OSH. Categorically, they have excluded these three. I mean, a hotel, restaurant, and eating places. I think everyone has noted it down. And OSH not applied to offices of central government, state government, or ship of war of any nationality, but offices of central government, state government will come under OSH if it employ contract labor. So this is the only thing. If they employ contract labor, then it will come under OSH.
Can you go back to one slide earlier?
Okay, which one, sir? This one or earlier? Hotel one?
Yeah, hotel one. Yeah, here when you say does not include mobile unit belonging to the armed forces, union, roadways, etc., etc. here. But when you talk about the hotel and the restaurant, I do not know any specific reason why it is not required, because when we talk about the hotel and restaurant, definitely there is a occupational safety and hazard issues are actually involved. Fire accident can take place and
no, sir, you are right. You have pointed it correctly. But what they have said that the last para, threshold will not matter. I think for this, there is a one confusion. Actually, they want to say hazardous or life-threatening activities being carried on. If it is at all, it is carried on, then they have to. I think, sir, you are right. But what government might have thought, you know, eating places like Thela Wala and something like any place they stand there, it will be very difficult for them to comply, you know, these things. That is what I feel. This may be the reason, but your question is, I mean, 100%. Now hotel comes, 5-star hotel also.
Yeah, that is what I'm thinking. That is the bigger people, like the 5-star hotel, they can get away with this if this is what they meant actually.
Yes, no, the eating places, I want to say, restaurant eating places, they also come under this exclusions. But yes, actually, sir, earlier under the Factories Act, hotels were excluded. Hotels and hospitals were excluded from the Factories Act. So maybe on the basis of that theory, they have excluded hotels, restaurant, or eating places. That is my.
Anyway, as we go on for the implementation, we can see some more notification comes on that.
Yeah, notification definitely. Definitely. I mean, I'm sure about that, it, because I'm going through the law. As I can see, there are so many places we have, you know, something, it is not clear. So government has to clarify all these things. But yes, I'm sure that the Factories Act was not applicable. So maybe because of that, they have done this.
Mr. Bala and Mr. Shantanu. So we have many HR people who has joined us. I would be very happy, you know, to receive them. We have a Rajendra Patel, Mr. Rahul Datar, Ayer, you know, from Nasik, and Mr. Jagannath from Hyderabad, you know. So we welcome you all, you know, and I would also request them to, you know, share their also experience. So Rajendra, bhai, you are there, Rajendra Patel?
Yeah, I'm here, Mr. Mehta.
Okay.
I'm here.
Okay.
I'm here.
So,
I'm here.
Okay, please, you know, so we'll be very happy because if you people handle those things, you know, HR, you know, on a day-to-day. And yeah, so we are lucky to have this. Rajendra Bhai is a very senior HR consultant. I know him personally and I requested him to be a part of this discussion. So welcome you, Rajendra Bhai. And of course, you know, we have other people also, Rahul Datar, you know, and Ayer from Nasik, and Jagannath also, you know, from Hyderabad. Yeah, so we welcome you all. Yeah, Shantanu, so you can continue. Yeah.
Yeah, nice to see all HR people here. So key concepts, I was talking about key concept. Now, initially Bala sir has asked me salary and wage slip and whether these are different. So actually, I just wanted to demonstrate that thing to everyone, but somehow I couldn't incorporate that thing in my slide. So let's put it this way. If wage is a subset, wage is a subset of total remuneration, it is a small portion. Actually, it should be at least 50%. That's what government want to say. It should be at least 50% of whatever you are getting. The 50% should be the wages. And this wage, now this is very important definition, because so many provisions talks about wage, and wage. Wages should be at least 50%. In short, I'm telling you, because the definition I have not covered. If you want, I will explain that separately through Excel if you want. Otherwise, I'm just telling you in brief that wage should be at least 50% of the overall remuneration, and whatever retirement benefits like PF or something you have to, calculate, it should be calculated on the wages. So I think most of you must be aware that earlier the basic DA, this is the only thing at which the provident fund contribution used to be calculated, and companies deliberately used to keep that basic and DA minimum, and so many allowances and so many bonus or commissions or some different things. So the actually they wanted to pay less and less provident fund contribution from employer side. That
Someone
was
is asking, please explain wages 50% and all in Excel.
yeah.
See,
Yeah. Okay,
to answer this question, nowadays the thing is moving in such a way in an organization, what you call the CTC. That way your total CTC will be so much. So you can decide the way you want to draw the salary, etc. and all those things coming. Suppose a person is actually getting about 50,000 rupees. Out of that, if it is 30,000 rupees is actually termed as a basic, then the provident fund has to be paid 8% or 10% or 12%, 15%, whatever applicable on the 30% of the basic. Now what happens is equally the employer has also contributed a similar amount. Now what people do, although the total salary is 50,000 rupees, they don't want to pay the provident fund. Even the employee want the money in the hand, he doesn't want to contribute, etc. So what they say, the basics only 5,000, rest all the thing 45,000. That is the way it is decided. If I understand Shantanu correctly, if
Yes,
50,000 rupees is there, minimum that 50% of that, that is 25,000 has got to be necessarily a basic salary which has to go for the contribution purposes. That is what the law is making it here. That means they wanted to safeguard the retirement benefits for the employees who are serving in their post-retirement. So there should be adequate retirement is taken care of. The contribution is available to them when they retire and peacefully live. That is the whole purpose here. Because the whole idea is they don't want to get, draw in such a way that a very bare minimum is kept for the purpose of fulfilling the law or something. That is what it is done here.
Actually, because of the wrong practices over the years by the industry, the government had to take this step. It was forced by the industry itself to the government that you do. We will be doing like that only. So government had made this provision under pressure, I think, because otherwise it will be very difficult for. I think, are you able to see my Excel sheet?
Now we are able to see.
Because this is very interesting aspect. And now this, I think there are few questions which came from big experts also. And I had done some analysis on that. So a lot of things will be clarified, I guess. First of all, the overall, whatever an employee gets, it will be treated as all the remuneration. First of all, remuneration. We are talking a remuneration. Okay. Now, in remuneration, if you see, there is a basic dearness allowance, and there is another retaining allowance. So actually the idea is anything goes beyond this exclusions will come into the wages. So retaining allowance, they have said. Now please focus on this. These items are very, very crucial to understand for HR people, for everyone actually. What is happening? What government is trying to say that the wage will exclude all these things. First of all, they are saying it will exclude whatever you say, like statutory bonus payable, other than terms of employment, whatever statutory is there, value of house accommodation, contribution paid to pension or provident fund by the employer part, then commission payable. Try to understand commission. People get commission on sales or something like that. So commission payable, everything government is saying, okay, exclude from wages, exclude. Even conveyance allowance, house rent allowance, amount payable under any award or settlement and overtime. Try to understand that this is the definition. They are saying that wages, initially they are saying that wages will include basic DA and RA, retaining allowance, and all these will be excluded. Okay. And after a few lines, I have also mentioned gratuity payable on termination, retrenchment compensation on retirement, ex gratia payment made to him at the actually these are not wages at all, because these are, you know, retirement. At the time of retirement you are paying something amount, so in any case it is not a wages. So I have kept it totally separately to them. Now try to understand. They say that, but if this portion, if this exclusions, try to understand that if exclusion is more than 50% of the overall total remuneration, then the excess will be treated as the wages for the purpose of calculating the retirement benefit. I mean that wages ki definition mein wo aa jayega. So what I want to tell you, suppose basic DA and RA is 20,000. I'm combining this because it doesn't matter in which place they are. Then I have combined these four, although all are exclusions, but I am specifically combining first four: bonus, house accommodation, it is value and everything as 10,000, and other conveyance allowance, house rent allowance, amount payable, what overtime. This is 10,000. Now you can see that if this exceeds the 50% of the overall. So what is the overall? The overall is 40,000, and it is not exceeding right now because it is 20,000. So in this case, since it is not exceeding the overall, the wages will be only this much. Have you understood this point? Because now it is Excel. Actually, I'm not able to draw because I have uploaded one lecture on wages, fully explained that on my YouTube channel. But here in Excel, it is very difficult. Now the next thing, which is very, very important, which you have to understand. Okay. This says that as far as equal wages to all genders and for the purpose of payment of wages, try to understand, for payment of wages and equal remuneration for, you know, all the genders, equality, equal remuneration, equal pay, equal remuneration. I mean, for that purpose, these items, you know, these will be included in the definition of wages. In the definition of wages, for which item they are talking about? For equal remuneration. I am giving you example, equal remuneration example, and payment of wages. Now payment of wages first. Let's talk about payment of wages. See, law everywhere talks about pay the wages. Okay, by this time, let's say pay the wages by next month, 7th of next month. Okay, it talks about wage payment. First of all, it is not talking about salary. So whenever we talk about payment of wages, we have to pay the wages. The wages will include basic DARA and all these. These will be included. Whenever we talk about payment of wages, whenever we talk about equal remuneration to male and female for equal work, we have to include all these four as the wages definition. Okay. So for example, again, it is a bit complicated, I can understand. but bear with me one more time. For example, somebody has to receive by 7th his payment, wages. So payment of wages, whenever it comes, the definition will include 20,000 and 10,000. He has to receive 30,000 by 7th of the next month. Are you getting this point? Now, this is not included in the definition of wages whenever we talk about the payment of wages. Because you can see value of house rent accommodation. It is a value how you can pay. Statutory bonus will be payable anytime, not monthly. Try to understand next 7 months, every month you cannot expect. Contribution paid to Provident Fund, amount to defray special expenses anytime, and commission payable to employee. All these will not be treated as wages. Yes, it is a remuneration. It is a due. It is a due to the employee. He can claim that due, but he cannot claim it as a wages. He can claim it as a due. This is what the thing is all about. Now, many people are saying, now you can see that this is also excluded from the definition of wages. Retirement benefits. And many people are saying that you have to settle everything within 2 days. You must have heard, I think those who have ventured into this, they must have heard this thing, that if employee is retrenched, you have to settle within 2 days. Okay. Everything. You cannot say that 3 months ke baad aana hum gratuity aur wo sab nikal ke rakhenge. It is not like that. But that section is different, which is saying that section is not saying 2 days. That section is saying immediately you have to pay. In case of retrenchment, you have to pay the amount of compensation, retrenchment compensation immediately at the time of retrenchment. These are the wordings. It is not coming as a wage. So I think it is getting very hot, but it is.
No, you're right, actually. We don't understand the framework, because here what happens is, as you rightly said, when you talk about the structure of the wages, that is basically remuneration, whatever you call it, the structure, when they are talking about it, that 50% concept is actually sitting there. So that means you cannot design your structure without having a 50% for the wages, which has to necessarily go for the contribution purpose of your retirement benefit. Very clear.
Yeah.
When you are coming to the payment of the wages, yes, it is not only what they are talking, that basic 50%, even all the other things like conveyance, etc., which are actually in cash, which is actually payable.
By 7th, you have to pay. By 7th, you have to pay.
By 7th of the next month. He cannot say, I'll pay only 20,000 rupees, rest I'll pay later. That escape cannot be done here. That is why when it is coming to the payment of wages, it comes.
Yes.
And then when you are talking about the value of the accommodation, it is only for the purpose of taxation purposes. It is actually a derived value. Notional value, which is actually derived. There is no payment is as such is involved there. Yeah. We don't understand this, interpretation and the mind of the.
But I don't know, because I didn't work as a HR, but HR people also mentioned that the value of house accommodation, definitely they must be mentioning that.
Correct.
So nothing to pay. It is just value you have to show you are already using. And commission payable to employee. Please remember that. Suppose, I just want to clarify this point here itself. Suppose one person is employed in your organization, and the terms are like that. Whatever sales he will generate, you will give, let's say, 20% of the sales generated. Okay. Try to understand this very important point. Now, the thing is, what will happen? Suppose employee has generated sales. You might have not received the cash. We don't know whether you have received the cash or not, but he has generated the sales. As per accounting term, we know what is sales. Now, if he is leaving or you are retrenching the employee, then commission payable will be as per the terms of your employment, whatever, as far as commission on sales is concerned, because it is not a payment of wages. Try to understand. It is his due, no doubt. Gratuity, retrenchment compensation, everything we have to pay, that is also clear. But this aspect, they have excluded from the definition of wages, although it is a claim, but you can delay that payment. That is what my understanding about this whole, bifurcation and all these things, and how we interpret the law.
Another thing is that in case of the same Excel sheet, if the 10 plus 10, 20, if that goes up, even the 10 goes to 15 or that overall goes to 25 or something like that, then what will happen is 50% only will be taken there, balance 50% will be taken as a deemed wages, and you are supposed to make the contribution for retirement benefit on that. That is what that will happen.
Yes, that is the core principle.
And second thing is there is one person is actually asking a question. I think there is a question from Shyam Savant. Overtime is actually variable. If it increases 1 month, this ratio will change for the basic salary. I think in overtime, although you say the overtime is variable, there is actually a ceiling is there of overtime. How much overtime can actually come within that ceiling? If within that ceiling, if it is there, it will never exceed 50%.
Okay, so they are, I mean, the Mr. is saying, like gentleman saying, overtime is variable.
If it is increased 1 month beyond this ratio, the ratio changes. I don't think so, because the overtime is actually settled because government doesn't want the people to, have a more stress and etc. They are always put a ceiling. Even it was also there earlier also.
Number of hours, actually, overtime hours will be fixed by the government. Still, it is in the process.
Correct.
The government is going to fix the number of hours of overtime. So employee cannot exceed those number of hours. The employer want to go for overtime, you can go for it, but cannot exceed the desired number of, ceiling overtime. Now, as far as if it is variable, it doesn't matter. I mean, you just have to check every month. Yes, you have to check every month if it is variable. As far as payment of wages and everything is concerned, you have to check every month actually, to be specific. Any other question like on this? Because
no, nothing is there. I read out all the questions.
Actually, there is one more, wages in kind. That is one more provision. I'm not covering here because it is already too hot now to handle. So I'm just skipping that. 15% of the wages you can pay in kind. That's what the provision says. And minimum wages, it is linked to that minimum rate of wages that I will talk about later on. I think remuneration, I think now it is quite clear to you, everyone, that remuneration is a broad term and wages is a subset. Okay. And retirement benefit will be calculated on wages, and wages itself is fluctuating for two purposes, equal remuneration and all these. We have to consider 4 exceptions we have to include, right? And payment of bonus, we will not include that. Bonus calculation, only basic DA or whatever 50% will be coming like that. So after that, let's come to employee and worker. This is also very important because there are certain rights which are available to worker, which are not available to employee, because it is for the protection of worker. Worker is weaker. So government want a category. So total employee, there is a subset which we will call them worker. So technically, if you see, everyone is employee, and except these persons, what have mentioned, I'm just giving you a basic idea. Manager or any person in admin capacity, administrative capacity, manager or administrative capacity will not be treated as worker. And supervisor, now supervisor is basically supervisor.
Shantanu, you would like to go back to the slide again?
Which one, sir?
You want to run the slideshow again? Then probably we'll have to close this and start sharing the slide. Oh, Excel sheet is appearing.
Oh, yeah. Extremely sorry. I didn't realize that. Thanks for reminding me, actually. Now, we have discussed about this, an employee and worker. So as I mentioned that workers basically, some protection is given to worker because of the weaker section of the society. And there is very little difference. Why I'm saying only people who are, first of all are employee, and out of all are employee, let's say 100 are employee, out of 190 will be worker, 10 will be out of worker, they will be normal employee. So manager or administrative capacity will not be included in the definition of worker, and any supervisor drawing more than 15,000 per month wages, he will not be treated as worker. Now, in IRC, industrial relation means strike, lockout, retrenchment purposes. OSH means for factory purposes. This limit of supervisor, they have kept it 18,000. I mean, so any supervisor drawing salary more than 18,000 in factory for the purpose of factory or for the purpose of strike will be treated as employee, not worker. But as far as payment of wages and all these are concerned, supervisor drawing like more than 15,000 wages will be treated as employee, will not be treated as a worker. So this is a difference actually of the ceiling. So this is the difference between employee and worker. So we will, whenever we study the provision, we have to check it is for employee or worker. So that is the basic difference here of employee and worker. Now, minimum rate of wages. This is very interesting point, and it will. I have very special thing I have noticed here in minimum rates of wages. So I would like to, share with you all. See, minimum rates of wages earlier, it were applicable only for certain industry. Government was, not bound, but expected to fix the minimum rate of wages only for certain industries. Okay, not for all. And I have received so many phone calls. Sir, we have not, हमको payment कम मिलता है वो, but government, even जो certain whatever certain establishment were there, government did not government need not to. It was not fixing the minimum rates of wages for those establishments also, and it was like zone. Government will arbitrarily decide the area and then decide for this area this minimum. Now everything will change. Everything will change. This is a very, very important provision in labor law in the history of India, you can say. The thing is that now the minimum rate of wages will be throughout India. Throughout India. It is not in Maharashtra, there is some state or some, some jilla or area, there will be some rates. It will be throughout India, minimum rates of wages will be fixed. First point. How it will be fixed? Because in city, Mumbai or Delhi, cost of living is high. Second tier city bit lower than a village, very low. So they have divided the whole India into 3 areas, geographical location, you can say. One will be metropolitan area. Metropolitan area. Second is non-metropolitan area, and third is rest is rural area. Rest India will be rural area. Now, metropolitan area means any area, compact area of one or more district having population more than 40 lakh. For example, Delhi. There are so many districts in Delhi, and combining together, it is going ahead of 40 lakhs. So government will fix, whenever government will fix the minimum rates of wages for unskilled, semi-skilled, skilled, and highly skilled. These 4 categories of wages will be there. Okay, whenever government will fix the minimum rate of wages, it will be fixing for unskilled, semi-skilled, skilled, and highly skilled. In metropolitan area, in non-metropolitan area, and in rural area. So roughly we can assume that there will be 12 types of rates, minimum rates of wages will be there. So multiplicity of minimum rates of wages have been avoided here. Now, second point, there will be a standard benchmark for minimum rates of wages. That is, the central government will fix the floor rates of wages, floor. So any state government cannot fix the minimum rate of wages below that floor rate. Because, you know, if you see today, MP mein kitna hai? 2,500 something. Maharashtra mein 10,000 something like that. Minimum rates of wages. So much of difference. You know, just border cost karte hum yahan se udhar jate. So much of difference. Now, floor rate will ensure the uniformity, at least minimum this much should be payable to each and every person who is falling under the minimum rates of wages. Okay. And appropriate government can fix above that, not below that. Okay. Have you understood the floor? It is a benchmark of minimum. Below that, government cannot go, even state government. Now, my question is there, what I have done, I have gone through Schedule E. Basically, Schedule E is very interesting. Schedule E talks about who will be skilled, who will be unskilled, who will be semi-skilled, and who will be highly skilled. I mean, the occupations are mentioned in the Schedule E. I'm just giving one example. For example, driver is mentioned in Schedule E in skilled section. So if there is a driver who is working in metropolitan area, okay, and metropolitan area skilled wages, minimum rate of wages is, let's say, 15,000, he should get that. If the driver is operating in non-metropolitan area and the area for that, the minimum rate are 12,000, he will get that. And if he is in rural area, he will get that rural area. Are you getting my point? Now, the thing is that, very interesting, it is actually a big topic. It is not clear, according to my analysis, it is not clear that each and everyone will be eligible for minimum rate of wages, or only those occupations which are mentioned in Schedule E. For example, driver is mentioned in Schedule E. Okay. So we can say that, okay, driver is in Schedule E, in skilled, then he will be able to get the wages. There are same title is given in different skills. For example, gardener is given under unskilled and semi-skilled both. Now you have to decide, the company has to decide. There is a form also, employee register, and in that there is a column that for each employee, you have to mention the skill level of that employee. So companies are supposed to, you know, categorize all the employee who are working in which occupation, whether they are in skilled or semi-skilled or highly skilled or unskilled, because it will be a matter of dispute later on if they have mentioned highly skilled, and if he is not actually a highly skilled job, it is not a highly skilled job, but he can claim on the basis of your letter of appointment that I'm highly. So you have to check the Schedule E, first of all, designation, whatever you are giving, you have to check the Schedule E. Now, another thing about Schedule E is that government has a right through committee, which it can keep on adding or deleting the entries from this occupational list of occupations which is given in Schedule E. So my feeling, what I feel that uh, if a person is, let's say, a software engineer, he is highly skilled person. Okay. But if highly skilled software engineer is not mentioned in Schedule E, then he may not claim the minimum rate. So it is not clear. I'm just trying to interpret. The government will have to come with some clarification on that. Okay, this is my interpretation. Whatever I thought, I shared with you. Okay.
So you're actually right. What you're saying is correct. There are so many designations which are actually given in the various organizations. We are not able to trace in the Schedule E today. So what is going to happen to them is actually a real question mark.
Yeah, it is a real, and companies will have to check the Schedule E.
Yeah.
Whether it is, matching. There is some definitions also. Unskilled means what? Semi-skilled means what? And skilled and highly skilled means what exactly?
Probably whatever the designation you give, the company may have to do the exercise of where exactly they are spilling, whether they are fitting in a skilled or highly skilled, semi-skilled, whatever it is, that fitting is to be done, and accordingly they should actually make the wage structure. That's what I think.
Yes, because see, they have given the definitions also. In the rules, they have given the definition, not in the act. They have given the definition, all these definitions in the rules, Code and Wages Central Rules. And the purpose of defining these things, that you check and you mark that employee, whether it is falling under highly skilled, semi-skilled, you check yourself, because definitions are given. Now, as far as minimum rates of wages are concerned, it will be whether he will be able to claim or not. You have to check the Schedule E. That's what I feel. But government will have to come up with some clarification.
So that means basically the companies have to do the skill matrix exercise.
Yes.
Yeah, that is what it appears.
It is actually professionally, if you see, professionally, if you want to run, you should have some logics. Job is what kind of job and what kind of person you are appointing. So there should be some logic, some professional thing. I think business should be run professionally. That's what I feel this law suggests.
Can I actually classify a person highly skilled, although he is not highly skilled, because I want to pay him more?
Yeah. That question actually, it came in my mind. For example, there is a PhD person who has done doctorate, and you have appointed him as a peon, or let's say unskilled. Whether he will be eligible for high skill or so, please remember here the occupation matters. We have to see the occupation, what he is doing. For example, highly skilled person is doing unskilled job, then he will be able to claim only unskilled, and vice versa. If unskilled person is appointed at a occupation which is highly skilled, he can claim the highly minimum wages fixed for highly skilled. The government will not check whether the person is capable or not. You have to check.
You rightly touched upon the point. In fact, I remember in our organization long back, maybe 30-40 years back, we wanted to employ a person. He wanted to employ a person as a, administrative officer for the particular job. A person was applied very, very highly qualified.
Oh.
Chartered accountant, company secretary, cost accountant, internal auditor, MBA, whatnot, etc. and other things.
Oh.
And ultimately, the company has found that he is fit to do this administrative job. The company has offered the job, and the company has got the particular salary for that particular position which they have offered. The person said, no, this salary is very less compared to my qualifications. You should pay me 3 times than what you are offering. Then only I will accept the job. I will not accept the job. Immediately, my management said, you may be having a many qualification immaterial. But what I did is, this is the minimum requirement. This is the job content. This is what the job content for which I will pay.
Yes.
So as you rightly said, he may be a PhD, but I don't need a PhD. for this particular job. So because he is a PhD, I cannot pay the higher salary.
Yeah, actually, as far as minimum rates of wages is concerned, both vice versa is also equally true. If you just had unskilled and fit at a highly skilled position, he will be able to claim the highly skilled wages, fixed for highly skilled wages, minimum wages.
Correct. Here, Rajendra is actually putting a view.
Yeah.
Job fitment has to be done carefully for fixing or calculating of the wages as per the geographical area. That is right. That's what I said actually. You know, the skill matrix exercise has to be done to classify, you know, one of these categories, and again according to the geography which is mentioned there in 3 locations. Yeah.
One more thing which I would like to tell you, add here, that see the minimum rate of wages, the earlier regime, what we have seen, fix ही नहीं किया, fix किया भी तो revise किया 10-15 सालों में. Now government has done that. Provision is that the government will revise the DA component of that. So basically, minimum rate of wages will be comprised of so many components, and there is a DA component, daily allowance, and that will be revised by the government every 6 months. Every 6 months. So 1st April and 1st October, the government will be revising these daily allowance. So minimum rates of wages will be, you know, change every April and October. So management who appoint bare and minimum rate of wages, they should be very careful that in the month of April, they should check the minimum rate of wages. If there is any change, they immediately should change. Otherwise, there will be a default of less payment and less payment, actually, violation. So that is also important thing in this regard. Now, appropriate government is, it was earlier also like so many acts, you will see that to whom you have to approach in case of a problem, let's say industrial dispute or whatever. So the thing is that there are 2 sets of government because it's in concurrent list. So in all codes, you will see there is an appropriate government, and appropriate government means central and state government. In short, if we talk about to who will be your master, let's say establishment, I should refer state government or central government. So there is one simple test. If the establishment is controlled, if the establishment is controlled by the central government, having the control over the central government, then appropriate government will be central government, wherever the factory is located. Okay. And if it is not having control of central government, then the appropriate government will be state government. I think this is important point. It is important when we have to go to any authority or something, then it is very important. And there is one more point is PSU. If PSU is, let's say central government is having more than 50% share in that PSU, and after commencement of this act, if the share even goes down, still the appropriate government will remain central government for that PSU. This is specifically they have mentioned there.
More or less the position is the same what was there in the earlier act also, because the earlier also we had.
Earlier, earlier they were classified as per the industries, actually.
Yeah, but earlier there used to be a central factories act, and the individual state government used to have their own factories act.
Yeah, no.
So here, as you rightly say, the government, the particular industry which are government directly by the central government. The appropriate authorities was the central government. Obviously, the public sector undertaking were also under the central government only, not the state government.
Yeah, but in case of OSH,
yeah,
okay, there is one point in OSH. In OSH code only, I'm talking about OSH, not other codes, because it's a matter of factory. What they says in the appropriate government definition in clause 2, in relation to factory, motor transport undertaking, plantation, newspaper establishment and establishment relating to BD cigar, including the establishment not specified in clause 1. Okay, जो ऊपर नहीं है वो भी सब आ जाएंगी. The concern state government where it is situated. तो जहां भी वो factory situated है, that state government will be the appropriate government for that, for factory also. I think I tried to figure it out why they have done this, because see, factory is very sensitive place, and what I feel that it is better to be handled by the local government wherever it is situated. It is specifically definition. I'm talking about OSH code. If you want, I will be able to, read. It is a big definition. I will be able to read the whole definition. For the removal of doubt, it is hereby clarified that state government shall be the appropriate government in respect of occupational. Clearly, they have mentioned state government shall be the appropriate government in respect of occupational safety, health, working condition in a factory situated in that state. Doesn't matter who is controlling it.
Rajendra is actually putting up skill matrix has to be vouched in much details. That is what he is saying.
Skill matrix, so you have to check. I mean, the company should check, right?
Skill matrix has to be, is using the word vouch.
Yeah, vouch. You have to vouch for the skills because government want every establishment to be professional. They should do their acts professionally. They should hire right person for right place. So the establishment should be aware of the skill set and the position which what it demands, and they should be able to match it. That's the only thing government trying to say.
Jagdish is asking, it is mentioned that the metro railways also come under the central government under the definition of appropriate government. But many metro rail corporations are under 50-50. JV shareholding with the state government having more administrative role vis-a-vis such a motor rail corporation. They be considered as a central government or the state government? Please clarify.
Yeah, actually there is a gray area. Okay, I haven't dived into that honestly. I want to dive there, but still I haven't gone there. But as far as definition in OSH code is given, in relation to other than those specified in clause 2, carried on by or under authority of central government concerning any such control by central establishment or the establishment of railway, including metro, railways, mines, oil fields, major ports, air transport service, telecommunication, banking, all these by what I'm called, by central act or a corporation or other authority established by a central or central subsidiary company set up by a central public sector undertaking or bodies owned or controlled by them, including establishment of contractor for the purpose of establishing corporation. So the definition is trying to say if the body, if that establishment is formed under central act, then the appropriate government will remain the central government. If it is formed under central act, company, any insurance company established by central act or a corporation or other authorities, I think this is little bit, they are talking about that. And the thing they are saying that if it goes beyond 50%, still the central government will be the appropriate authority. So that this is what they want to tell actually. The gray area is there, but they should come up with some clarification. This is what I feel, because here the picture is quite blurred. Not categorically they have mentioned about dropping, state government is having this much control. So what will happen? But the only say, if it is going down, it will remain with the central government. Central government will remain appropriate. And in factories case, they've categorically said that it will be state government. I hope little bit is clear now. I think you can ask me later on also. I will definitely try to upload and I will let you know. But the government will have to come up with some FAQs on this. We can ask this question to government.
Yeah, that is right.
Now, after that, gender discrimination is very, very important point. And I have seen many HR people, they are doing just, I don't know what they are doing. I mean,
Moderator is also saying the metro rail concern, this is actually a gray area because there are judgments with the various high courts interpreting this issue either way.
no, that is the thing. The government is still not clear with it, so they haven't mentioned in the act itself. So basically, they have to clarify. We cannot draft the law. So maybe because
you're right actually, because as you rightly said, what happens is metro. In many places, the state government is actually administrating, monitoring, doing the things, etc., and all those things. Although the central government is putting up a project. So accordingly, the things vary. As you rightly say, some clarification need to come up. Yeah.
Actually, I have seen one case where people were struggling to find where to go. The establishment was trying to find to where to go, and when they go to state government, they say no, you have to go to central. Central say no, you have to go to state. Finally, they used to go to the High Court for writ petition and to order the authority where we should go, and they have to hear. Like this was the action earlier. So
I think we move on because we are already 1 o'clock.
Yeah. I wanted to ask you actually time 1 o'clock, but I have so many things. But okay, no problem. But there are a lot of things to be covered. Actually, thank you so much for attending this webinar. I'm extremely, happy and feel privileged to, interact with all.
We can have a part 2 also, sir. I think.
No, we can have a part 2 if you have a more coverage
separate.
with that. We can schedule according to your availability.
Yeah.
Actually,
So,
I'm waiting for audience reactions and their expectations. So if you can gather those things and let me know about exactly.
Sure, why not? Let us ask the audience. I would like to turn into more part of it because
so
we have covered. Yeah, we have covered around 50% only today.
Yeah.
What is the interest?
So
can I hear from the audience?
Yeah.
Actually, I'm not able to.
So we can have a part 2. Yeah, we need this.
Yeah, here many people are actually saying that we want to have a part 2. People are showing interest actually. There are many answers are coming. Yeah.
So Shantanu, next time we can come with a lot of FAQs also, because rather than just giving a one way. So probably I'll ask request participant to write to us to
yeah, it will be better.
Kind of
If you can take one question in advance, and we will work with that, and we will cover all those questions in the presentation itself.
So I have put in my this mail ID. So you can, if you have any kind of questions, so we can cover it up, next presentations. And all are invited. This is a free webinar. You can even send it to your colleagues, friends. Any HR people can participate. There is no charges. It's all a kind of a exchange of knowledge. So we are bringing all the good faculties on this platform so that the knowledge can be distributed. Yeah, Mr. Balakrishnan.
I can see more and more requests are coming for having other sessions.
Yeah.
And so in fact, it will be helpful. We can schedule.
I will be happy for that. The only thing which I wanted to know, their feedback. I am always interested in feedback, whether we are going on the right track, like whether they are getting what exactly they are looking for. So if you can get the feedback so for this
Sure.
session.
Sure,
In fact,
sir.
there are-
Yeah.
Shantanu, there are a lot of things which people are saying it's a very good information what you have
Okay, thank you so much
given,
for that.
and it's a wonderful webinar. So much insight we are hearing. Those things are also coming here. If you can
Okay.
actually open the chat box, you can also see it.
Yeah, now
is there
I can
actually.
see like Rupali and it's Rupali. Okay. Okay, great. Thank you so much, Rupali. Ashwini wants recording for that. So recording will be available.
Recording
because-
is actually
Yes,
made
yes.
available at the end of the session. That
Yeah.
we do it, people will get it actually. There's no problem.
Yeah, so this will be available on our YouTube channel, maybe after 2-3 days, once we get compiled properly. Then we'll upload in the YouTube.
Okay,
Without even saying the second part, it will
after
be
2-3 days, right? It will be
Yeah,
available.
after 2-3 days. So please, you can subscribe to this our channel also, YouTube channel, so that you will get those regular webinars like this. Yeah. Yeah, Mr. Bala, I think we should close.
Yeah. That's what I think so. So we
Yeah,
can
I
schedule
was-
the part 2. You can isolate with him, and we can finalize the appropriate things probably. Yeah.
Okay.
Yeah.
Okay.
Thank you.
We will have a part 2 session. We will announce it once it is finalized. Yeah.
Okay, thank you, Mr. Shantanu, and thank you, Mr.
Okay.
Bala, for this wonderful presentations. I think this is, I think all of us, we have a lot of curiosity about this new labor code, and I think all of us, we have to unlearn and relearn the new act. So thank you once again, all of you, and attending this webinars on a large number. Thank you very much. So we'll close this session. Thank you, Shantanu, and
Thank you, everybody.
Mr. Bala.
Thank you,
Thanks a
everyone.
lot to
Thank you, sir.
everybody. Thank you. Have a good day.